Two girls were arrested for a Facebook post. Not for hacking, not for threats, not for spreading false information. One of them didn't even write the post. She clicked like. That's it. She clicked like on someone else's words, and the police came to her door. Her name was Rinu Srinivasan. She was 21 years old. The girl who wrote the post was Shaheen, also 21. They were arrested under a law called Section 66A of the Information Technology Act, a law so broadly written, so dangerously vague, that it could put you in prison for anything the government decided was offensive online. This is the story of how two ordinary girls from Mumbai started a chain of events that went all the way to the Supreme Court of India, and how that court, in a ruling that stunned legal scholars across the world, tore that law apart completely. This is Docket Decoded, and this is Shreya Singhal v. Union of India. To understand why two young women were arrested for a Facebook post, you need to understand what was happening in Mumbai in November 2012. Bal Thackeray, the founder of Shiv Sena, one of India's most powerful regional political parties, had just died. He was 76 years old. His death triggered a complete shutdown of Mumbai. Shops closed, trains stopped. The city went quiet out of what was described as mourning, though for many residents, the shutdown felt less like grief and more like enforcement. Shaheen was watching all of this from her home in Palghar, a town near Mumbai, and she had a thought, the kind of thought that millions of people had that day, but didn't say out loud. She posted it on Facebook. She questioned whether the shutdown was genuine mourning, or something closer to intimidation. She asked why an entire city should grind to a halt. It was not a violent post. It contained no threats, no abuse, no specific target. It was one young woman's opinion, typed on her phone, shared with her friends. Rinu Srinivasan, her friend, read it, and clicked like. That was the entirety of their offense. Within hours, local Shiv Sena workers had seen the post. They filed a complaint, and the police, under pressure, in a politically charged atmosphere, arrested both girls under Section 66 of the Act. Shaheen's uncle's orthopedic clinic was vandalized the same night. Her family was threatened. The two girls were released on bail within hours, but the damage was done, and something had been exposed, a law so elastic, so undefined, that it could be stretched to silence anyone. If you had posted that same thing from London or New York, nothing would have happened. We'll come back to that. The arrests became national news, then international news. A law student in Delhi named Shreya Singhal had been following the story. She was 21 years old, the same age as Shaheen and Rinu, and she decided to do something that most people never do. She filed a public interest litigation in the Supreme Court of India, arguing that Section 66A was unconstitutional, that it violated Article 19 of the Indian Constitution, the right to freedom of speech and expression. One student, one petition, against the entire government of India. To understand why this case mattered so much, you need to understand what Section 66A actually said. The law was introduced in 2008 as an amendment to the Information Technology Act. Its stated purpose was to deal with online harassment, cyberbullying, and threatening messages sent through electronic means. That sounds reasonable, and parts of it were, but Section 66A went much further than that. It made it a criminal offense to send any information through a computer or mobile phone that was, and I'm quoting directly here, grossly offensive, menacing in character, or causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will. Read that list again. Annoyance, inconvenience, insult. These are not crimes. These are Tuesday mornings on the internet. Here's the simplest way to understand what was wrong with Section 66A. Think of it this way. Imagine a rule in your neighborhood that says no one is allowed to say anything that disturbs anyone else. Who decides what counts as disturbing? Whoever is most easily disturbed. Whoever has the loudest complaint. Whoever has the most power. That is what Section 66A handed to the government, and to anyone with political connections, who wanted to silence a critic, a journalist, or a student with an opinion. The maximum punishment was 3 years in prison. No warrant required in some interpretations. No judicial oversight before arrest. And between 2012 and 2015, it was used, repeatedly, against journalists, cartoonists, academics, and ordinary citizens. Still with me? Good. Because here is where the Supreme Court steps in, and what they said is extraordinary. Before we get to the verdict, understand the legal standard that the court had to apply. In Indian constitutional law, free speech under Article 19 is not absolute. The Constitution allows restrictions, but only on specific grounds. National security, public order, defamation, obscenity. These are called reasonable restrictions. The question before the Supreme Court was this: is annoyance a reasonable restriction on free speech? Think of it this way. A second analogy. If you shout fire in a crowded theater, when there is no fire, that causes panic. That causes real harm. That is a reasonable restriction. But if you write a Facebook post, saying you disagree with the political shutdown, who's harmed? What threat does that pose? The court was being asked to draw a line between speech that causes harm and speech that causes discomfort, and the government was arguing that discomfort was enough to imprison someone. The case of Shreya Singhal v. Union of India was heard by a 5-judge constitutional bench of the Supreme Court of India. This is the highest level of judicial scrutiny in the Indian legal system, reserved for cases where the constitutionality of a law is directly challenged. The bench was led by Justice J. Chelmsford and Justice R.F. Nirman, two of the most respected legal minds in modern Indian judicial history. The government argued, as governments always do, that the law was necessary, that the internet was a new and dangerous space, that without Section 660, the state had no tool to control online speech that could inflame communities, incite riots, destabilize the peace. Shreya Singhal's lawyers had a different argument, and it was devastatingly simple. They said, show us the standard. Show us the line where offensive ends and criminal begins. Because Section 660 draws no such line. And the government could not draw that line, because the law had never drawn it. The court examined case after case, where Section 660 had been used. A professor arrested for forwarding a WhatsApp message. A cartoonist jailed for his drawings. A businessman detained for posting a critical comment about a politician. In each case, the standard had been whatever the complainant decided. There was no objective test, no definition, no threshold. And then, on the 24th of March 2015, the Supreme Court delivered its judgment. Unanimous. 5 judges. 5 different minds. One single conclusion. Section 660A of the Information Technology Act was unconstitutional. Struck down. Completely. Not amended. Not restricted. Gone. Justice Nirman, writing for the bench, held that the provision was void for vagueness, a term borrowed from American constitutional law, meaning that a law which gives no clear standard to citizens or to police is no law at all. It is simply power, dressed in legislative clothing. But before I tell you why this verdict sent shockwaves well beyond India, there's something the headlines missed entirely. The Supreme Court didn't just strike down Section 660, it drew a boundary that India had never drawn before, a distinction between advocacy and incitement that changed the entire framework of online speech law in this country. And this case didn't just change India, it put every government watching on notice. Here is the distinction the court made, and it is one of the most important ideas in free speech law anywhere in the world. There is a difference between discussion, advocacy, and incitement. Discussion is, here is an idea, let us examine it. Advocacy is, I believe this idea is right, and you should too. Incitement is, this idea demands that you act now and harm someone. Only incitement, the court said, can justify criminal restriction under Indian constitutional law. Discussion and advocacy, even of unpopular ideas, even of ideas that offend, are protected. Section 660 had treated annoyance as incitement. The court said, that is not a law, that is a weapon. And if you think this is just an Indian problem, stay with me, because the rest of the world is fighting the exact same battle right now. So what actually changed because of this case? In the immediate term, Section 660 was dead. No arrest, no prosecution, no police complaint could legally invoke it from that day forward. But the ruling went further than just one bad law. The Supreme Court held that any law restricting speech online must meet the same constitutional standard as laws restricting speech offline. The internet is not a special category where governments get extra powers. Citizens do not surrender their fundamental rights when they log on. That principle sounds obvious in 2026. In 2015, before most governments had even begun seriously legislating the internet, it was radical. If you're finding this useful, subscribe before we get to the global angle, because this is where it gets interesting. And what happened to Shaheen and Rinu? Their arrests were eventually dropped. No conviction, no prison time. But Shaheen's family's clinic had been vandalized. Her family had been threatened. The harm had already been done. The law had been used exactly as a weapon is used, not necessarily to convict, but to intimidate. That is the real cost of vague laws. The punishment happens before the court date. And Shreya Singhal, the law student who filed the pill, she completed her legal education. She is now a practicing lawyer. Do you think the verdict was the right call? Tell me in the comments, because there are serious people who argued the other side. Now, here is where this case fits into a global conversation that is happening right now in every country with an internet connection. India's verdict, Section 660, is gone, but the question it raised, who decides what is grossly offensive online, is still being debated everywhere. In the United States, the First Amendment draws the line at incitement, not offense, not discomfort, not annoyance. Section 660 could never have existed in America in that form. It would have been struck down in a federal court within months. In the United Kingdom, the Online Safety Act, which came into force in 2024, creates a category called legal but harmful content. Content that is not illegal, but which platforms must still manage. Critics say this is Section 660 in a British suit. The government says it is proportionate regulation. The argument is live. In Australia, the eSafety Commissioner has broad powers to order the removal of online content, powers that have been used against journalists and political speech. The same tension, the same unanswered question, who is the arbiter of harm? And back in India, Section 660 is gone, but its shadow remains. States have used other provisions to arrest critics, journalists, and students for online posts. The battle that Shreya Singhal won in the Supreme Court is still being fought in district courts across the country. The law moves slowly. The internet moves fast. And somewhere in that gap, ordinary people get caught. The universal question this case leaves us with is this: in a democracy, who gets to decide what speech is too offensive to be allowed? If the answer is the government, you have Section 660. If the answer is no one, you have a different set of problems. The Supreme Court of India said, at minimum, the standard must be clear. The citizen must know, in advance, what the line is. Vagueness is not a law. It is a blank check for power. That is the legacy of Shreya Singhal, and it belongs to everyone. I'm your host on Docket Decoded. Every verdict has a story. This one started with a girl who clicked like. If this case surprised you, the next one will too. Subscribe and hit the bell, and I'll see you in the next breakdown. And as always, nothing in this video is legal advice. For any legal matter in your jurisdiction, please consult a qualified attorney. This was Docket Decoded.